Let's talk about who can challenge your will. Because you, like many people, may think that once you do a will, that's automatically going to control your assets upon your passing, but that isn't the way it works, because many people pass away without a will, and in light of that, the legislature has passed laws that say if you die without a will, if you have a spouse and no children, your spouse inherits your property. If you die without a will and you have children and no spouse, then your children inherit your property. If you die with a spouse and children, then your spouse gets the first $50,000 off the top, and your spouse and children split the rest 50-50 among them, with the spouse getting half and the children splitting the other half. If you pass away with no spouse or children, your parents inherit your estate. If you pass away with no spouse or children and your parents predecease you, then your siblings inherit your estate without a will, and if they pass away, their children step into their shoes. If you don't have any siblings or nieces and nephews living, then it goes to cousins and all the way down to cousins once removed. So when we're filling out the paperwork to submit a will to the court, we find the nearest relatives and we express them. We do a family tree showing the court who they are, and those are the people who have a right to challenge your will. If they want to challenge your will, they can request years' worth of medical records and financial records, and it can become quite cumbersome and difficult. So if you suspect someone may want to challenge a will, there are ways to avoid it by using trusts and beneficiary designations and so forth. And we encourage you to listen and watch other videos on this site to see how that can be done.